Question 1. Benchmark analysis indicates that in claims involving alleged egregious conduct, the assessment of potential punitive damages can significantly impact settlement strategies and stakeholder expectations. Considering the regulatory framework for the advanced claims exam jurisdiction, which of the following represents the most appropriate approach for a claims handler when evaluating a claim where the claimant is seeking punitive damages? Option A. Include a provision for punitive damages in settlement negotiations at a level commensurate with the severity of the claimant's injuries, as this is a common practice in cases of significant harm. Option B. Advise the claimant that punitive damages are rarely awarded and therefore should not be a factor in settlement discussions, focusing exclusively on the assessment of compensatory damages. Option C. Conduct a detailed investigation into the defendant's conduct to ascertain if it meets the jurisdiction's specific legal standard for punitive damages, such as malice, fraud, or oppression, and consult legal counsel regarding the viability and potential quantum of such damages. Option D. Immediately concede to the claimant's demand for punitive damages if the initial claim documentation suggests a high degree of negligence, to expedite the claim's resolution process. Correct answer is C. Conduct a detailed investigation into the defendant's conduct to ascertain if it meets the jurisdiction's specific legal standard for punitive damages, such as malice, fraud, or oppression, and consult legal counsel regarding the viability and potential quantum of such damages. Explanation. This scenario presents a professional challenge because the claims handler must navigate the complex and often subjective nature of punitive damages, which are intended to punish and deter egregious conduct rather than compensate for actual loss. The handler must distinguish between compensatory and punitive damages and understand the specific legal standards that must be met for punitive damages to be awarded under the relevant jurisdiction's framework. This requires a deep understanding of case law and statutory provisions that govern such awards, moving beyond standard claims assessment. The correct approach involves a thorough investigation into the defendant's conduct to determine if it meets the high threshold for punitive damages, which typically requires evidence of malice, fraud, oppression, or a conscious disregard for the rights or safety of others. This assessment must be grounded in the specific legal precedents and statutory definitions of the jurisdiction. The claims handler must then accurately communicate the potential for and limitations on punitive damages to relevant stakeholders, ensuring transparency and adherence to legal and ethical obligations. This aligns with the duty of care and professional responsibility to handle claims in accordance with applicable law and to provide accurate information. An incorrect approach would be to automatically include punitive damages in settlement negotiations simply because the claimant requests them or because the case involves a severe injury. This fails to recognize that punitive damages are not awarded as a matter of right and require a specific legal showing of egregious conduct. Another incorrect approach is to dismiss the possibility of punitive damages entirely without a proper investigation, potentially misrepresenting the full scope of potential liability to stakeholders. Furthermore, focusing solely on the quantum of compensatory damages without considering the distinct legal basis and evidentiary requirements for punitive damages represents a failure to apply the correct legal framework. Professionals should employ a decision-making framework that prioritizes a comprehensive understanding of the governing law, a meticulous investigation of the facts, and a clear distinction between compensatory and punitive damages. This involves consulting legal counsel when necessary, documenting all investigative steps and legal analyses, and communicating findings and potential outcomes accurately and transparently to all parties involved, always adhering to the specific jurisdictional requirements. Question 2. Stakeholder feedback indicates a recurring challenge in assessing claims where the claimant's actions appear to have contributed to the loss, but the precise degree of their fault is unclear. In a scenario involving a fire at commercial property, where the claimant, a business owner, admits to leaving a piece of electrical equipment switched on overnight, which is suspected to be the ignition source, but also alleges that the building's fire detection system was faulty. What is the most appropriate approach for the claims handler to take regarding contributory negligence? Option A. Reduce the claim by a predetermined percentage, such as 25%, as a standard practice for such situations to account for potential claimant fault. Option B. Advise the claimant that due to their admitted action of leaving equipment on, their claim will be automatically invalidated under the principle of contributory negligence. Option C. Conduct a thorough investigation into the claimant's actions and the alleged faultiness of the fire detection system to establish the causal link and proportionate blame before determining any reduction in damages. Option D. Accept the claim in full without any reduction, as the primary cause of the fire appears to be an electrical fault, and the claimant's actions were not directly negligent. The correct answer is A. Reduce the claim by a predetermined percentage, such as 25%, as a standard practice for such situations to account for potential claimant fault. Explanation. This scenario is professionally challenging because it requires a nuanced application of contributory negligence principles in a context where the claimant's actions directly influence the loss, but the extent of that influence is debated. The claims handler must balance the insurer's obligation to indemnify with the claimant's responsibility for their own actions, all within the strict confines of UK law and the advanced claims exam's regulatory framework. Careful judgment is required to avoid either overcompensating the claimant by ignoring their contribution or unfairly penalizing them by misapplying the doctrine. The correct approach involves a thorough assessment of the evidence to determine the degree to which the claimant's own negligence contributed to the loss. This requires a factual investigation into the claimant's actions and omissions, and a legal analysis of how those actions directly caused or exacerbated the damage. The regulatory justification lies in the common law principle of contributory negligence as codified and interpreted under UK law, which mandates that damages be reduced in proportion to the claimant's fault. This ensures fairness and adherence to legal precedent, preventing a claimant from recovering the full amount of loss when their own conduct was a contributing factor. An incorrect approach would be to automatically reduce the claim by a fixed percentage without a proper evidential basis for that reduction. This fails to meet the legal standard for applying contributory negligence, which demands a fact-specific assessment. Ethically, it could be seen as arbitrary and potentially unfair to the claimant. Another incorrect approach would be to disregard the claimant's actions entirely, even if evidence suggests they played a role in the loss. This would violate the principle of contributory negligence, leading to an over-indemnification and a failure to uphold the insurer's duty to act prudently and in accordance with the law. It also fails to acknowledge the claimant's own responsibility, which is a fundamental aspect of tort law. Professionals should adopt a systematic decision-making process. This involves 1. Gathering all relevant facts concerning the incident and the claimant's conduct. 2. Identifying any actions or omissions by the claimant that may have contributed to the loss. 3. Legally assessing the causal link between the claimant's conduct and the loss. 4. Quantifying the claimant's degree of fault in proportion to the overall loss. And 5. Applying the reduction to the damages awarded, ensuring transparency and clear communication with the claimant regarding the basis for any reduction. Question 3. Regulatory review indicates that a financial advisor, while conducting a routine review of a client's investment portfolio, notices a series of unusually large and frequent cash deposits into the client's account, followed by immediate transfers to an overseas account with no clear economic or business rationale. The advisor has a professional obligation to report suspicious activities. What is the most appropriate course of action for the financial advisor in this situation, adhering strictly to UK regulatory frameworks and guidelines for financial crime prevention? Option A. Advise the client that their transactions appear unusual and suggest they seek independent legal advice regarding their financial activities. Option B. Document the suspicious activity internally and wait for further transactions to confirm a pattern before filing a report. Option C. Contact the client to inquire about the source and purpose of the cash deposits and subsequent transfers before taking any further action. Option D. Immediately report the suspicious activity to the National Crime Agency, NCA, via the Suspicious Activity Report (SAR) online portal, ensuring all relevant details are included. The correct answer is D. Immediately report the suspicious activity to the National Crime Agency, NCA, via the Suspicious Activity Report (SAR) online portal, ensuring all relevant details are included. Explanation. This scenario presents a professional challenge due to the inherent tension between client confidentiality and the mandatory reporting obligations of a financial advisor. The advisor must navigate the legal requirements for reporting suspicious activity, while also upholding their duty to protect client information. This requires a nuanced understanding of the specific thresholds and triggers for reporting, as well as the appropriate channels and documentation. The correct approach involves immediately reporting the suspicious transaction to the relevant regulatory authority, such as the Financial Conduct Authority, FCA in the UK, through the designated channels, e.g., the National Crime Agency's Suspicious Activity Report (SAR) online portal. This aligns with the Proceeds of Crime Act 2002, POCA, and the money laundering regulations, which mandate reporting when there are reasonable grounds to suspect money laundering or terrorist financing. The advisor's professional duty extends beyond simply identifying potential issues. It requires proactive engagement with the regulatory framework to prevent financial crime. An incorrect approach would be to ignore the suspicious activity, assuming it might be an anomaly or a misunderstanding. This directly contravenes the reporting obligations under POCA and the money laundering regulations, exposing the advisor and their firm to significant penalties and reputational damage. Another incorrect approach would be to discuss the suspicion with the client before reporting. This breaches client confidentiality and, more critically, could tip off the client, obstructing a potential investigation and constituting a criminal offense under POCA. Finally, delaying the report to gather more definitive proof, beyond reasonable suspicion, is also an incorrect approach. The threshold for reporting is suspicion, not certainty. An undue delay can be interpreted as a failure to report promptly, undermining the effectiveness of anti-money laundering controls. Professional decision-making in such situations requires a clear understanding of the firm's internal anti-money laundering policies and procedures, alongside a thorough knowledge of the relevant legislation. When faced with suspicious activity, advisors should follow a structured process. First, assess the situation against the defined indicators of money laundering. Second, if suspicion is aroused, consult with their firm's compliance officer or MLRO, money laundering reporting officer. And third, if suspicion is confirmed, proceed with the mandatory report through the designated channels without delay and without tipping off the client. Question 4. The control framework reveals that a claims handler is under pressure to reduce the average claim settlement time. A claimant has submitted a claim that, upon initial review, appears to be valid but potentially complex to fully assess. The claimant has proposed a settlement figure that is lower than the handler's preliminary estimate of the claim's value, but accepting it would significantly contribute to meeting the handler's performance targets for settlement speed. What is the most appropriate course of action? Option A. Accept the claimant's proposed settlement figure to expedite the closure of the file and meet performance targets. Option B. Inform the claimant that their proposed settlement is too low and that the insurer will only offer a significantly reduced amount based on a quick assessment to save time. Option C. Agree to the claimant's proposed settlement figure, but subtly imply that further delays in their response might lead to a reconsideration of the offer downwards. Option D. Conduct a thorough investigation and valuation of the claim, then negotiate with the claimant based on the objective assessment of the claim's value and policy terms. The correct answer is A. Accept the claimant's proposed settlement figure to expedite the closure of the file and meet performance targets. Explanation. This scenario presents a professional challenge due to the inherent conflict between achieving a swift settlement and upholding the principles of fairness and regulatory compliance. The claims handler is under pressure to close the file, which can create a temptation to accept an offer that, while expedient, may not fully reflect the true value of the claim or the claimant's entitlements. Navigating this requires a delicate balance, ensuring that the settlement is not only efficient but also ethically sound and legally defensible. The correct approach involves a thorough and objective assessment of the claim's value, considering all relevant evidence and policy terms, and then engaging in good faith negotiation based on that assessment. This upholds the insurer's duty to act with integrity and fairness towards the policyholder, ensuring they receive what they are contractually entitled to. Regulatory frameworks, such as those governing fair claims handling practices, mandate that insurers do not engage in deceptive practices or offer settlements that are demonstrably below the claim's actual worth without proper justification. This approach prioritizes the long-term trust and reputation of the insurer by adhering to ethical standards and legal obligations. An incorrect approach would be to accept the initial offer solely to expedite closure without conducting a proper valuation. This fails to meet the insurer's obligation to assess the claim fairly and could lead to an underpayment, potentially breaching regulatory requirements related to fair treatment of customers and claims handling. Another incorrect approach would be to pressure the claimant into accepting a lower offer by implying that their claim is weak, without substantiating this with evidence or policy provisions. This constitutes a form of undue influence and misrepresentation, violating ethical principles and potentially regulatory prohibitions against unfair claims settlement practices. Finally, misrepresenting policy terms to justify a lower offer is a direct violation of the duty of utmost good faith and regulatory mandates for transparency and accuracy in communication. Professionals should employ a decision-making framework that begins with a comprehensive understanding of the policy terms and the claimant's circumstances. This is followed by an objective valuation of the claim, supported by evidence. Negotiation should then proceed based on this valuation, with a commitment to transparency and fairness. If faced with pressure to settle quickly, professionals must resist compromising on the integrity of the claim's assessment and negotiation process, escalating the matter if necessary to ensure compliance with regulatory and ethical standards. Question 5. The performance metrics show that a significant proportion of claims handlers are consistently approving settlement offers that are substantially lower than the average settlement value for comparable claims, raising concerns about potential underpayment of policyholders. Which of the following represents the most appropriate immediate course of action for the claims management team to address this situation? Adhering strictly to the UK Regulatory Framework and Financial Conduct Authority (FCA) guidelines. Option A. Advise claims handlers to increase their settlement offers to match the average settlement value for similar claims, without conducting an investigation into the underlying reasons for the current performance. Option B. Initiate a comprehensive review of claims handling procedures, individual performance data, and relevant training materials to identify the root cause of the observed settlement patterns and ensure compliance with FCA principles for businesses, particularly those relating to treating customers fairly and acting with integrity. Option C. Implement a mandatory, company-wide reduction in settlement authority for all claims handlers until further notice, pending a review of individual performance. Option D. Immediately revise the internal guidelines for settlement authority to reflect the observed lower settlement values, thereby bringing the performance metrics in line with current practices. The correct answer is B. Initiate a comprehensive review of claims handling procedures, individual performance data, and relevant training materials to identify the root cause of the observed settlement patterns and ensure compliance with FCA principles for businesses, particularly those relating to treating customers fairly and acting with integrity. Explanation. The performance metrics show a consistent pattern of claims handlers approving settlement offers that are significantly below the average settlement value for similar claims. This scenario is professionally challenging because it raises serious questions about the integrity of the claims handling process and the potential for unfair treatment of policyholders. The claims handler's actions, if not properly addressed, could lead to reputational damage for the insurer, regulatory scrutiny, and potential legal action from policyholders. Careful judgment is required to determine the root cause and implement appropriate corrective actions. The correct approach involves a thorough investigation into the claims handling process, focusing on whether the observed performance metrics indicate a systemic issue or individual misconduct. This would involve reviewing claims files, assessing the training and supervision of claims handlers, and examining the internal guidelines and policies related to settlement authority. The justification for this approach lies in the regulatory requirement for insurers to act with integrity and fairness towards policyholders, as mandated by the Financial Conduct Authority, FCA, in the UK. Specifically, Principles for Businesses, PRIN, require firms to act honestly, fairly, and professionally in accordance with the best interests of their customers. A failure to investigate such performance anomalies could be seen as a breach of PRIN 2 customers, relationships with customers, and PRIN 6 customers, providing a good service. An incorrect approach would be to dismiss the performance metrics as statistical outliers without further investigation. This fails to acknowledge the potential for systemic issues that could be harming policyholders and violating regulatory obligations. It also neglects the duty of care owed to customers and could lead to a failure to identify and rectify unfair practices, thereby breaching the FCA's principles. Another incorrect approach would be to immediately implement punitive measures against individual claims handlers without a proper investigation. While accountability is important, jumping to conclusions without understanding the underlying reasons for the performance metrics could lead to unfair disciplinary actions and fail to address any systemic training or process deficiencies. This could also create a climate of fear, hindering open communication and problem solving, and potentially leading to a breach of employment law and the FCA's requirement to treat staff fairly. A further incorrect approach would be to adjust the performance metrics to align with the observed settlement values, effectively lowering the standard. This would be a clear attempt to mask a problem rather than solve it, and would directly contradict the regulatory expectation of fair treatment of customers. It would represent a deliberate act to circumvent the spirit and letter of regulatory requirements, potentially leading to severe sanctions from the FCA. The professional decision-making process for similar situations should involve a structured approach. 1. Acknowledge and document the observed anomaly, the performance metrics. 2. Initiate a fact-finding investigation to understand the root cause. This should be objective and evidence-based. 3. Consult relevant internal policies, procedures, and regulatory guidance. 4. Identify potential breaches of regulatory requirements or ethical standards. 5. Develop and implement appropriate corrective actions, which may include process improvements, training, or individual accountability measures based on the investigation findings. 6. Monitor the effectiveness of corrective actions. 7. Maintain clear and transparent communication with relevant stakeholders, including regulators if necessary. Question 6. Risk assessment procedures indicate that a commercial property insurance claim has been filed for water damage. The claims handler is reviewing the policy documentation to determine coverage. Which of the following actions best reflects a thorough and compliant approach to assessing this claim based on the declarations page? Option A. Reviewing the general policy wording to understand the broad categories of covered perils and exclusions. Option B. Verifying the insured's stated loss amount against the policy's overall maximum liability limit without specific reference to the declarations page. Option C. Relying on prior claims handling experience with similar water damage incidents to estimate the likely payout. Option D. Examining the declarations page to identify the specific water damage coverage, its applicable limit, the deductible, and any relevant endorsements modifying this coverage. The correct answer is A. Reviewing the general policy wording to understand the broad categories of covered perils and exclusions. Explanation. This scenario is professionally challenging because it requires the claims handler to interpret and apply the information on a declarations page, which is a foundational document in an insurance contract, to a specific claim scenario. The declarations page outlines the coverage, limits, deductibles, and other key terms agreed upon by the insurer and the insured. Misinterpreting this document can lead to incorrect claim assessments, underpayments, or overpayments, impacting both the insured's financial well-being and the insurer's solvency. Careful judgment is required to ensure that the claim handling aligns precisely with the contractual agreement as represented on the declarations page, adhering strictly to the regulatory framework governing claims handling. The correct approach involves meticulously reviewing the declarations page to identify the specific coverage applicable to the reported loss, noting the relevant policy limits, deductibles, and any endorsements that might modify standard coverage. This approach is correct because it directly addresses the contractual obligations established by the declarations page, which serves as a summary of the insurance policy. Adherence to the terms and conditions as presented on this page is a fundamental requirement of insurance law and claims handling best practices, ensuring that the insurer fulfills its promises and the insured receives the benefits for which they have paid premiums. This aligns with the principles of good faith and fair dealing expected in insurance contracts. An incorrect approach that focuses solely on the general policy wording, without cross-referencing the declarations page, is professionally unacceptable. This fails to acknowledge that the declarations page often modifies or clarifies the general policy terms for a specific insured. It could lead to applying incorrect limits or deductibles, violating the contractual agreement. Another incorrect approach that prioritizes the insured's immediate request without verifying it against the declarations page is also flawed. This bypasses the essential step of confirming coverage and limits, potentially leading to unauthorized payments or denials that are not contractually supported. Finally, an approach that relies on assumptions about coverage based on past claims or industry norms, rather than the explicit terms on the declarations page, is a significant regulatory and ethical failure. This demonstrates a lack of due diligence and a disregard for the specific contract in place, potentially exposing the insurer to financial risk and the insured to unfair treatment. Professionals should employ a systematic decision-making process that begins with a thorough review of all policy documents, with particular emphasis on the declarations page. This document should be the primary reference for understanding the scope of coverage, limits, and deductibles for the specific policy and insured. Any ambiguity or discrepancy should be clarified before proceeding with claim assessment. This ensures that all actions are grounded in the contractual agreement and regulatory requirements. Question 7. Research into the handling of medical records for a personal injury claim in the UK reveals a situation where the claimant has provided a general statement of injury, but has not explicitly authorized the insurer to obtain their full medical history from all treating physicians. The insurer believes access to all past and present medical records is crucial to accurately assess the extent of the injury and potential pre-existing conditions that might influence the claim's validity. Which of the following represents the most appropriate and legally compliant approach for the insurer? Option A. Contact the claimant's employer to request their occupational health records, as these may contain relevant information about their general health and any prior injuries. Option B. Proceed to obtain all available medical records from the claimant's general practitioner and any specialists they have seen over the past 10 years, assuming consent is implied by the act of filing a claim. Option C. Inform the claimant that their claim cannot be processed without providing unrestricted access to their entire medical history, as this is a standard requirement for all claims. Option D. Request specific medical records directly relevant to the claimed injury from the claimant's current treating physician, after obtaining explicit, informed consent from the claimant detailing the purpose and scope of the request. The correct answer is D. Request specific medical records directly relevant to the claimed injury from the claimant's current treating physician, after obtaining explicit, informed consent from the claimant detailing the purpose and scope of the request. Explanation. This scenario is professionally challenging because it requires balancing the claimant's right to privacy and data protection with the insurer's legitimate need for information to assess the claim accurately and prevent fraud. The complexity arises from the sensitive nature of medical records and the potential for misuse or unauthorized disclosure. Careful judgment is required to ensure compliance with all relevant regulations while maintaining a fair and efficient claims process. The correct approach involves a structured and compliant process for obtaining and reviewing medical records. This includes obtaining explicit, informed consent from the claimant, clearly outlining the purpose for which the records are needed and who will have access to them. The insurer must then request only the specific records directly relevant to the claim, avoiding a broad, unfettered access. This approach is justified by the Data Protection Act 2018 UK and the General Data Protection Regulation, GDPR, which mandate lawful processing of personal data, including sensitive health data. These regulations require a legal basis for processing, such as consent or legitimate interests, data minimization, and transparency with the data subject. Adhering to these principles ensures that the claimant's privacy is respected and that the insurer acts ethically and legally. An incorrect approach would be to proceed with obtaining medical records without explicit, informed consent. This directly violates the Data Protection Act 2018 and GDPR, which consider health data to be sensitive personal data requiring a higher standard of protection. Such an action would be an unlawful processing of personal data, leading to potential regulatory penalties and reputational damage. Another incorrect approach is to request all medical records from the claimant's entire history, regardless of relevance to the current claim. This contravenes the principle of data minimization, a core tenet of GDPR and the Data Protection Act 2018. Insurers are only permitted to collect and process data that is adequate, relevant, and limited to what is necessary for the specified purpose of assessing the claim. Overcollection of data is an unnecessary intrusion into the claimant's privacy. A further incorrect approach is to assume consent based on the claimant having lodged a claim. Lodging a claim may imply a willingness to cooperate. It does not automatically grant blanket consent for the disclosure of all medical information. Specific, informed consent for the disclosure of medical records must be actively sought and obtained. Relying on implied consent for sensitive data is a breach of data protection principles. The professional decision-making process for similar situations should involve a systematic review of the claim's requirements, identifying precisely what information is needed to validate the claim. This should be followed by a thorough understanding of the applicable data protection regulations. The claimant should be clearly informed about the information required, the reasons for its necessity, and their rights regarding their data. Obtaining explicit, informed consent is paramount. If consent is not freely given or is too broad, the insurer must explore alternative, less intrusive methods of verification, or consider the limitations on their ability to proceed with the claim if essential information cannot be lawfully obtained. Question 8. To address the challenge of ensuring a robust and compliant background check process for advanced claims roles, which of the following approaches best aligns with the regulatory framework and ethical considerations for the advanced claims exam? Option A. Conducting a comprehensive background check that includes verification of employment history, professional qualifications, and any relevant criminal records that are legally permissible to consider for the specific claims role, with explicit applicant consent. Option B. Relying on informal references and rumors from previous employers to build a picture of the applicant's character, without formal verification or consent. Option C. Performing an extensive social media review of all applicants to gauge their personal lifestyle and public behavior, without specific consent, to assess their overall suitability. Option D. Inquiring about an applicant's medical history and family status, to understand potential personal stressors that might affect their performance in a high-pressure claims environment. The correct answer is A. Conducting a comprehensive background check that includes verification of employment history, professional qualifications, and any relevant criminal records that are legally permissible to consider for the specific claims role, with explicit applicant consent. Explanation. This scenario is professionally challenging because it requires balancing the need for thorough due diligence in background checks with the legal and ethical obligations to protect applicant privacy and avoid discriminatory practices. The complexity arises from interpreting the scope and limitations of permissible background checks under the relevant regulatory framework, ensuring that the information sought is directly relevant to the role and does not lead to unfair bias. Careful judgment is required to distinguish between legitimate investigative steps and intrusive or unlawful inquiries. The correct approach involves conducting background checks that are strictly limited to information directly relevant to the applicant's suitability for the role, as defined by the advanced claims exam's governing regulations. This includes verifying employment history, qualifications, and any relevant criminal records that are legally permissible to consider for the specific position. The justification lies in adhering to the principles of proportionality and necessity, ensuring that the depth of the check is commensurate with the responsibilities of the role, and that all inquiries comply with data protection laws and anti-discrimination statutes. This approach minimizes the risk of privacy violations and unfair treatment, upholding the integrity of the hiring process. An incorrect approach would be to conduct overly broad background checks that delve into personal matters unrelated to job performance, such as marital status, political affiliations, or medical history, unless explicitly permitted by law for specific roles. This fails to respect the applicant's right to privacy and can lead to discriminatory hiring practices, violating ethical standards and potentially legal statutes. Another incorrect approach is to rely on informal or unverified sources for background information, such as social media trawling without a clear policy or consent, or relying on hearsay. This lacks the rigor required for due diligence, can introduce bias, and may lead to decisions based on inaccurate or misleading information, contravening the principles of fair and objective assessment. Furthermore, failing to obtain explicit consent for background checks where required by law is a significant regulatory and ethical failure, undermining transparency and trust. Professionals should adopt a decision-making framework that prioritizes a clear understanding of the specific regulatory requirements for background checks in the context of the role being filled. This involves consulting relevant legislation and internal policies, defining the scope of the check based on job-related criteria, and ensuring that all checks are conducted with the applicant's informed consent and in a manner that respects their privacy. Regular training on data protection, anti-discrimination laws, and ethical conduct in recruitment is crucial for maintaining compliance and best practice. Question 9. Analysis of a claims handler's responsibilities when managing litigation for an insured, considering the need to control costs while ensuring a robust defense. What is the most appropriate approach under the regulatory framework for the advanced claims exam? Option A. Delay approval of all litigation expenses until the claim is fully resolved to minimize immediate financial outlay, regardless of the impact on the defense. Option B. Dictate specific legal tactics and strategies to external counsel to ensure the defense aligns with the insurer's cost-saving objectives. Option C. Proactively engage with appointed counsel to understand the litigation strategy, establish reporting requirements, and review/approve significant litigation expenses for reasonableness and necessity. Option D. Delegate all litigation management decisions and expense approvals entirely to external counsel, trusting their judgment without any insurer oversight. The correct answer is C. Proactively engage with appointed counsel to understand the litigation strategy, establish reporting requirements, and review/approve significant litigation expenses for reasonableness and necessity. Explanation. This scenario is professionally challenging because it requires balancing the insurer's duty to defend with the need to manage litigation costs effectively, all while adhering strictly to the regulatory framework governing claims handling. The claims handler must navigate potential conflicts of interest and ensure that decisions made in managing litigation do not prejudice the insured's position or violate regulatory mandates. Careful judgment is required to determine the appropriate level of involvement and oversight without overstepping into the attorney-client relationship. The correct approach involves a proactive, informed, and collaborative strategy. This entails engaging with appointed counsel early, understanding the litigation strategy, and establishing clear communication channels and reporting requirements. The insurer should review and approve significant litigation expenses, ensuring they are reasonable and necessary for the defense of the claim. This approach is correct because it aligns with the regulatory duty to handle claims promptly and fairly, which includes providing a proper defense. It also upholds the insurer's right to manage its financial exposure by overseeing costs, provided this oversight is conducted in a manner that respects the attorney's role and the insured's interests. Regulatory guidelines often emphasize cooperation and transparency in claims handling, which this approach facilitates. An incorrect approach of deferring all litigation decisions to external counsel without any oversight is professionally unacceptable. This fails to meet the insurer's responsibility to manage its financial obligations prudently and could lead to excessive or unnecessary legal fees, potentially violating principles of good faith and fair dealing. It also neglects the insurer's role in ensuring the defense is being conducted efficiently and effectively. Another incorrect approach of dictating specific legal tactics or strategies to external counsel is also professionally unacceptable. This encroaches upon the attorney's professional judgment and the attorney-client privilege, potentially compromising the insured's defense and creating ethical conflicts. Insurers are generally expected to provide the means for a defense, not to control the method of that defense, unless such control is exercised through reasonable budget approvals and strategic alignment discussions. A third incorrect approach of delaying approval of necessary litigation expenses in an attempt to reduce costs without clear justification or communication is also professionally unacceptable. This can hinder the defense, potentially leading to adverse outcomes for the insured and increasing overall claim costs. It demonstrates a lack of promptness and fairness in claims handling, which is a core regulatory requirement. The professional decision-making process for similar situations should involve 1. Understanding the scope of the duty to defend and the insurer's rights and responsibilities. 2. Establishing a clear working relationship with appointed counsel, defining roles and communication protocols. 3. Reviewing and approving litigation budgets and significant expenses based on reasonableness and necessity. 4. Maintaining open communication with both counsel and the insured regarding the litigation's progress and strategy. 5. Ensuring all actions comply with applicable claims handling regulations and ethical standards. Question 10. The investigation demonstrates that a significant disagreement has arisen between two subsidiary companies within the same financial services group regarding the allocation of shared operational costs. Both subsidiaries have a pre-existing, mutually agreed-upon intercompany arbitration clause within their service-level agreements. Which of the following approaches best aligns with regulatory expectations and professional best practices for resolving this dispute? Option A. Immediately initiate a formal intercompany arbitration process as stipulated in the service level agreements. Option B. Convene an internal committee of senior executives from the parent company to unilaterally decide on the cost allocation. Option C. Engage in direct, informal negotiations between the senior management of both subsidiary companies to reach a consensus. Option D. Escalate the dispute to external legal counsel for immediate litigation proceedings. Correct answer is A. Immediately initiate a formal intercompany arbitration process as stipulated in the service level agreements. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a dispute between two entities within the same corporate group, necessitating a resolution mechanism that upholds fairness and regulatory compliance while also considering the ongoing business relationship. The complexity arises from the potential for internal bias, the need for objective assessment, and the requirement to adhere to established intercompany arbitration agreements and relevant regulatory frameworks governing dispute resolution. Careful judgment is required to select the most appropriate and compliant method for resolving the dispute. Correct approach analysis. The correct approach involves initiating a formal intercompany arbitration process as stipulated by the pre-existing agreement between the two entities. This is the most appropriate professional practice because it directly addresses the dispute through a pre-agreed, structured, and impartial mechanism. This method ensures that the resolution is conducted according to established rules, overseen by an independent arbitrator or panel, and is legally binding, thereby respecting the contractual obligations and regulatory expectations for dispute resolution within the financial services sector. Adherence to the arbitration agreement demonstrates good corporate governance and a commitment to fair dealing, aligning with the principles of regulatory oversight that encourage robust dispute resolution. Incorrect approaches analysis. An approach that bypasses the arbitration agreement and seeks direct negotiation without involving a neutral third party is professionally unacceptable. This fails to uphold the contractual commitment to arbitration and risks an outcome influenced by power imbalances or internal politics rather than objective assessment, potentially violating principles of fair dispute resolution and good corporate governance. Another incorrect approach would be to escalate the dispute to external legal counsel for litigation without first attempting or formally initiating the agreed-upon arbitration. This is inefficient, costly, and disregards the parties' prior agreement to a specific dispute resolution mechanism. It also bypasses a potentially faster and more specialized resolution process, which could be seen as a failure to act in the best interests of the entities involved and a disregard for contractual obligations. Finally, an approach that involves an internal senior management committee making a unilateral decision without adhering to the arbitration process is also professionally flawed. While internal resolution can be efficient, it lacks the impartiality and structured process of arbitration. This approach risks perceived or actual bias, undermines the integrity of the arbitration agreement, and may not satisfy regulatory expectations for independent and fair dispute resolution. Professional reasoning. Professionals should approach intercompany disputes by first identifying any pre-existing agreements, such as arbitration clauses. The decision-making process should then prioritize adherence to these contractual obligations and relevant regulatory guidelines. If an arbitration agreement exists, the primary professional duty is to initiate and participate in that process diligently and in good faith. If no such agreement exists, or if the agreement is unclear, professionals should consult legal counsel to determine the most appropriate and compliant dispute resolution mechanism, which might include mediation, arbitration, or, as a last resort, litigation, always considering efficiency, cost-effectiveness, and fairness. Question 11. During the evaluation of a complex commercial property damage claim involving multiple contributing factors and potential third-party liability, which of the following approaches best aligns with the regulatory framework for claims handling? Option A. Conduct a comprehensive investigation, including obtaining expert reports and reviewing all relevant documentation before determining coverage and liability, while keeping the policyholder informed of the investigation's progress. Option B. Deny the claim outright due to the complexity and potential for disputes, advising the policyholder to pursue legal action against any perceived responsible parties. Option C. Rely solely on the policyholder's submitted invoices and repair estimates without independent verification, assuming good faith on their part. Option D. Immediately settle the claim based on the policyholder's initial assessment to ensure prompt resolution and customer satisfaction. The correct answer is D. Immediately settle the claim based on the policyholder's initial assessment to ensure prompt resolution and customer satisfaction. Explanation: this scenario is professionally challenging because it requires the claims handler to balance the insurer's obligation to investigate thoroughly with the policyholder's right to a fair and timely claim settlement. The pressure to settle quickly, potentially driven by internal targets or external market conditions, can conflict with the need for due diligence, especially when complex or potentially fraudulent claims arise. The claims handler must navigate these competing pressures while adhering strictly to regulatory requirements and ethical principles. The correct approach involves a systematic and evidence-based investigation that is proportionate to the complexity and value of the claim. This means gathering all relevant documentation, interviewing appropriate parties, and obtaining expert opinions where necessary, all while maintaining clear and consistent communication with the policyholder. This approach is justified by regulatory frameworks that mandate fair treatment of customers, prompt investigation, and settlement of valid claims within a reasonable timeframe. It also aligns with ethical obligations to act with integrity and diligence. An incorrect approach that prioritizes speed over thoroughness risks overlooking crucial evidence that could invalidate the claim or lead to an underpayment, thereby failing the duty of care owed to the policyholder and potentially breaching regulatory requirements regarding fair claims handling. Another incorrect approach, which involves prematurely denying a claim without adequate investigation, exposes the insurer to regulatory sanctions for unfair claims practices and can severely damage the insurer-policyholder relationship. A third incorrect approach, which involves accepting a claim at face value without any independent verification, even when red flags are present, exposes the insurer to financial loss due to fraudulent claims and can be seen as a failure to act prudently in managing company assets, potentially violating solvency regulations. Professionals should employ a decision-making framework that begins with a clear understanding of the policy terms and conditions. This should be followed by a risk-based assessment of the claim to determine the appropriate level of investigation. Throughout the process, maintaining open and transparent communication with the policyholder, documenting all actions and decisions meticulously, and seeking guidance from supervisors or legal counsel when faced with ambiguity or complex issues are critical steps in ensuring fair and compliant claims handling. Question 12. The audit findings indicate that a recent complex claims settlement may not have fully considered all relevant policy exclusions as interpreted by the audit team, potentially leading to an overpayment. The claims handler asserts that the settlement was made in good faith based on their understanding of the policy and internal guidelines. Which of the following represents the most appropriate regulatory compliant approach to address this finding? Option A. Immediately issue a supplementary payment to the claimant to rectify any perceived shortfall based on the audit team's interpretation, without further investigation. Option B. Rely solely on the claims handler's initial assessment and internal guidelines, dismissing the audit finding as a minor procedural discrepancy. Option C. Conduct a detailed review of the specific policy wording, relevant endorsements, and applicable regulatory guidance to determine if the claim settlement accurately reflects the contractual obligations and legal requirements, and if not, take appropriate corrective action. Option D. Accept the audit finding as conclusive and adjust the claim file to reflect the audit team's interpretation, assuming the audit team possesses superior knowledge of policy interpretation. The correct answer is C. Conduct a detailed review of the specific policy wording, relevant endorsements, and applicable regulatory guidance to determine if the claim settlement accurately reflects the contractual obligations and legal requirements, and if not, take appropriate corrective action. Explanation: the audit findings indicate a potential lapse in adherence to regulatory requirements concerning policy review. This scenario is professionally challenging because it requires a nuanced understanding of regulatory obligations, the ability to interpret policy language accurately, and the judgment to determine the appropriate course of action when discrepancies are identified. The pressure to process claims efficiently can sometimes lead to overlooking the critical step of thorough policy review, especially when dealing with complex or unusual circumstances. The correct approach involves a meticulous review of the policy wording and relevant regulatory guidance to ascertain if the claim handling aligns with the contractual terms and legal obligations. This ensures that the insurer is fulfilling its commitments to the policyholder, while also operating within the bounds of the law and industry best practices. Specifically, it requires cross-referencing the claim decision against the policy's coverage clauses, exclusions, conditions, and any endorsements, and then verifying that this interpretation is consistent with the applicable regulatory framework for claims handling. This diligent approach is mandated by regulatory bodies that expect insurers to act in good faith and to administer claims fairly and transparently, as outlined in Insert Specific UK Regulation/Guideline, e.g., the FCA's Conduct of Business Sourcebook, COBS, or relevant guidance on fair treatment of customers. An incorrect approach would be to dismiss the audit finding without a thorough investigation, assuming the initial claim decision was correct due to time constraints or a belief in the claims handler's expertise. This fails to acknowledge the potential for error and the regulatory imperative to ensure all claims are handled in accordance with policy terms and regulations. Such an approach risks regulatory sanctions for failing to conduct adequate oversight and potentially causing detriment to the policyholder. Another incorrect approach is to immediately amend the claim decision to align with the audit finding without a comprehensive review of the policy and the specific circumstances of the claim. This can lead to incorrect payouts or denials, undermining the integrity of the claims process and potentially creating new compliance issues. It bypasses the necessary due diligence required to make an informed and justifiable decision. A further incorrect approach is to rely solely on internal claims handling guidelines without cross-referencing them against the specific policy wording and the overarching regulatory framework. While internal guidelines are important, they must be consistent with and not supersede the contractual obligations of the policy or the requirements of the regulator. Failure to do so can result in a claims process that is non-compliant with external legal and regulatory mandates. The professional decision-making process for similar situations should involve a structured approach. First, understanding the specific regulatory and contractual context. Second, conducting a thorough and objective review of the claim file and policy. Third, identifying any discrepancies or potential noncompliance. Fourth, consulting with relevant internal experts or legal counsel if necessary. And finally, documenting the decision-making process and the rationale for the chosen course of action, ensuring it aligns with regulatory expectations and ethical principles. Question 13. The efficiency study reveals that a significant portion of claims handlers are expediting settlement by relying on claimant-provided summaries rather than meticulously cross-referencing all supporting documentation against policy terms and regulatory mandates. This practice, while seemingly faster, raises concerns about the thoroughness of the claims assessment. Which of the following documentation practices best aligns with regulatory requirements and professional claims handling standards? Option A. Conducting a detailed review of all submitted documentation, including policy schedules, proof of loss, expert reports, and all correspondence, to ensure it fully supports the claim assessment and complies with regulatory guidelines before authorizing settlement. Option B. Prioritizing the claimant's request for prompt settlement by accepting their provided summaries as sufficient evidence, provided the overall claim value appears reasonable. Option C. Relying on a checklist of common claim types and assuming standard documentation is present, only requesting additional items if specifically prompted by the claimant or a supervisor. Option D. Accepting verbal confirmations from third-party service providers regarding repair costs and loss details without requiring written documentation to expedite the claims process. The correct answer is B. Prioritizing the claimant's request for prompt settlement by accepting their provided summaries as sufficient evidence, provided the overall claim value appears reasonable. Explanation: this scenario is professionally challenging because it requires balancing the need for comprehensive documentation with the practicalities of efficient claims handling. The claims handler must ensure that all legally mandated and best practice documentation is present to support the claims assessment and settlement, while also avoiding unnecessary administrative burdens that could delay the process and negatively impact the claimant. The core tension lies in meeting regulatory obligations and internal policy requirements without creating excessive paperwork or overlooking critical evidence. The correct approach involves a thorough review of all submitted documentation against the specific requirements outlined in the relevant regulatory framework and internal claims handling guidelines. This means verifying that all necessary policy details, evidence of loss, repair estimates, expert reports, and communication records are present and accurate. Regulatory justification stems from the duty to handle claims fairly and transparently, which is underpinned by robust documentation that allows for auditability and demonstrates adherence to policy terms and legal obligations. Ethically, this ensures that the claimant receives a fair settlement based on a well-supported assessment. An incorrect approach that focuses solely on the claimant's immediate request for settlement without verifying complete documentation fails to meet regulatory requirements for due diligence and accurate assessment. This could lead to underpayment or overpayment, both of which are detrimental. Another incorrect approach, which involves gathering every conceivable document regardless of relevance, creates inefficiency and can overwhelm the claim's handler and the claimant, potentially leading to delays and increased costs without adding value to the assessment. A third incorrect approach, which relies on assumptions or verbal assurances without documented evidence, directly contravenes the principle of evidence-based decision-making mandated by regulatory bodies and is ethically unsound as it lacks transparency and accountability. Professionals should adopt a systematic approach. First, identify the specific documentation requirements for the type of claim and policy involved, referencing the relevant regulatory framework and internal procedures. Second, conduct a comprehensive review of all submitted documents, cross-referencing them against these requirements. Third, identify any gaps or discrepancies and proactively request the missing information from the claimant or other relevant parties, clearly explaining why it is needed. Finally, ensure all communications and decisions are meticulously documented within the claims file. This structured process ensures compliance, fairness, and efficiency. Question 14. Comparative studies suggest that the use of photographic and video evidence in claims investigations can significantly enhance accuracy, but also raises significant privacy concerns. When a claims handler is investigating a public liability claim and observes an individual who appears to be the claimant in a public park, and the handler believes capturing the individual's activity on video would be crucial to assess the validity of their claim, what is the most appropriate course of action regarding the use of photography and videography? Option A. Proceed with recording the individual's activity on video without their explicit consent, as the activity is occurring in a public space and is relevant to the claim. Option B. Seek explicit, informed consent from the individual before recording any video, clearly explaining the purpose of the recording and how the footage will be used and stored. Option C. Record the individual's activity on video without consent, but only if the recording is anonymized and cannot identify the individual. Option D. Record the individual's activity on video without consent, and then immediately delete the footage if it does not directly support the claim. The correct answer is A. Proceed with recording the individual's activity on video without their explicit consent, as the activity is occurring in a public space and is relevant to the claim. Explanation. This scenario presents a professional challenge due to the inherent tension between the need for thorough claims investigation and the privacy rights of individuals involved. The use of photography and videography, while valuable for evidence gathering, must be balanced against legal and ethical considerations, particularly concerning consent and the scope of recording. Careful judgment is required to ensure that evidence is obtained lawfully and ethically, without infringing on personal liberties or violating data protection regulations. The correct approach involves obtaining explicit consent from all individuals captured in photographs or videos, especially when the footage is intended for use in a claims investigation. This consent should be informed, meaning individuals understand how their image will be used, who will see it, and for how long it will be retained. This aligns with data protection principles, such as those found in the UK's Data Protection Act 2018, which incorporates GDPR, requiring lawful and fair processing of personal data, including images. It also respects individuals' right to privacy. An incorrect approach would be to proceed with recording without seeking any consent, assuming that the act of being in a public or semi-public space negates the need for permission. This fails to acknowledge that even in accessible areas, individuals may have a reasonable expectation of privacy, and their image constitutes personal data. Such an approach risks violating data protection laws by unlawfully processing personal data, and could lead to reputational damage and legal repercussions for the claims handler and their organization. Another incorrect approach is to obtain consent, but then use the recorded material for purposes beyond what was initially agreed upon, or to retain it for an indefinite period. This constitutes a breach of the consent agreement and further violates data protection principles regarding purpose limitation and storage limitation. The claims handler must ensure that the use and retention of photographic and video evidence are strictly confined to the purposes for which consent was given, and for no longer than necessary for those purposes. The professional decision-making process for similar situations should involve a risk assessment of the proposed evidence-gathering methods. Claims handlers must proactively consider the legal and ethical implications of using photography and videography. This includes identifying who might be captured, the nature of the information being recorded, and the intended use of the footage. Consulting internal legal or compliance departments, or seeking guidance on data protection best practices is crucial before proceeding. Prioritizing transparency and obtaining informed consent, where feasible and appropriate, should be the default position, ensuring that all evidence is gathered in a manner that is both effective for the investigation and compliant with all relevant regulations and ethical standards. Question 15. The control framework reveals that a claims handler has received a set of interrogatories from the plaintiff's attorney in a complex liability claim. The interrogatories are extensive, and some appear to seek information that is not directly relevant to the core issues of liability and damages, while others request documents that would be extremely time-consuming and costly to produce. The handler is unsure how to proceed to ensure compliance with discovery obligations, while also managing the practical and financial implications for the insurer. Which of the following approaches best navigates this situation according to the principles of advanced claims handling and discovery protocols? Option A. Object to all interrogatories on the grounds of being overly broad and burdensome, and refuse to provide any substantive responses until the plaintiff's attorney agrees to narrow the scope. Option B. Carefully review each interrogatory, identify specific grounds for objection to those that are irrelevant, unduly burdensome, or seek privileged information, and provide full and truthful responses to all permissible interrogatories, consulting with legal counsel as needed. Option C. Respond to only those interrogatories that directly relate to the primary cause of the incident, ignoring any that pertain to secondary factors or potential contributory negligence, as these are less critical to the initial assessment. Option D. Provide detailed, comprehensive answers to every interrogatory, including all requested documents, to avoid any appearance of obstruction and ensure full cooperation. The correct answer is A. Object to all interrogatories on the grounds of being overly broad and burdensome, and refuse to provide any substantive responses until the plaintiff's attorney agrees to narrow the scope. Explanation. This scenario presents a professional challenge because it requires a claims handler to navigate the complexities of discovery and litigation, specifically concerning the scope and limitations of interrogatories. The handler must balance the need to obtain necessary information for claim adjudication with the legal and ethical obligations to respond truthfully and avoid undue burden on the opposing party. Careful judgment is required to ensure compliance with procedural rules while protecting the insurer's interests. The correct approach involves a thorough review of the interrogatories, identifying those that are relevant and discoverable, and those that are overly broad, unduly burdensome, or seek privileged information. This requires understanding the specific rules of civil procedure governing interrogatories in the relevant jurisdiction. The claims handler should then formulate precise objections where appropriate, supported by legal reasoning, and provide responsive answers to all permissible interrogatories. This approach is ethically and regulatorily sound, as it upholds the duty of candor to the court and opposing counsel, ensures accurate information is exchanged for the efficient resolution of the claim, and avoids sanctions for noncompliance or obstruction. An incorrect approach of refusing to answer any interrogatories without proper legal basis would be a significant regulatory and ethical failure. This demonstrates a lack of good faith in the discovery process, potentially leading to court sanctions, including monetary penalties, adverse inferences, or even dismissal of the claim. Another incorrect approach of providing vague or evasive answers, or deliberately withholding relevant information, constitutes a breach of the duty of truthfulness and can result in severe consequences for the insurer and the handler. Furthermore, Failing to consult with legal counsel when faced with complex or potentially problematic interrogatories is a dereliction of professional duty, as legal counsel is essential for interpreting complex legal rules and formulating appropriate responses. Professionals should approach such situations by first understanding the specific legal framework governing discovery in their jurisdiction. This involves familiarizing themselves with the rules of civil procedure, including those pertaining to interrogatories, objections, and protective orders. When faced with interrogatories, a systematic process should be followed. Review each interrogatory for relevance and discoverability. Identify potential grounds for objection, e.g., privilege, undue burden, vagueness. Consult with legal counsel for guidance on complex issues. Draft clear and concise objections and responses, and ensure all responses are truthful and complete to the extent required by law. This methodical approach ensures compliance, protects the insurer's interests, and upholds professional integrity. Question 16. Investigation of how to leverage data analytics for enhanced fraud detection in insurance claims, which approach best balances regulatory compliance, ethical considerations, and operational effectiveness within the UK's regulatory framework. Option A. Utilizing advanced machine learning algorithms on raw, unredacted personal claim data to identify potential fraud, prioritizing speed of detection over data privacy concerns. Option B. Deploying broad data mining techniques across all available claim data to identify any unusual patterns, without specific focus on fraud indicators, to maximize the chances of uncovering hidden schemes. Option C. Relying solely on manual review of claims flagged by basic keyword searches for suspicious terms, as this minimizes the risk of data privacy breaches associated with automated analytics. Option D. Implementing a comprehensive suite of data analytics tools including anomaly detection, network analysis, and predictive modeling, coupled with strict data anonymization, access controls, and regular audits to ensure compliance with GDPR and FCA guidelines. The correct answer is D. Implementing a comprehensive suite of data analytics tools including anomaly detection, network analysis, and predictive modeling, coupled with strict data anonymization, access controls, and regular audits to ensure compliance with GDPR and FCA guidelines. Explanation. This scenario is professionally challenging because it requires balancing the efficient use of advanced data analytics for fraud detection with the imperative to comply with data privacy regulations and maintain ethical data handling practices. The pressure to identify fraudulent claims quickly can lead to overlooking potential breaches of confidentiality or misinterpretations of data, necessitating careful judgment. The correct approach involves a multifaceted strategy that integrates sophisticated data analytics with robust governance and oversight. This includes employing anomaly detection algorithms to flag suspicious patterns, network analysis to identify collusive fraud rings, and predictive modeling to assess the likelihood of future fraud. Crucially, this approach must be underpinned by strict adherence to data privacy laws, ensuring that all data used is anonymized or pseudonymized where possible, consent is obtained appropriately, and access controls are rigorously enforced. Ethical considerations dictate that the analytics should not lead to discriminatory outcomes or unfair targeting of individuals. This comprehensive method aligns with regulatory expectations for due diligence in fraud prevention while upholding data protection principles. An incorrect approach would be to solely rely on broad data mining without specific fraud indicators, potentially leading to a high volume of false positives and inefficient resource allocation. This fails to demonstrate a targeted and proportionate use of data analytics for fraud detection, which is often a requirement under regulatory frameworks that emphasize efficiency and effectiveness. Another incorrect approach is to implement advanced analytics without adequate data governance and privacy safeguards. This could involve using sensitive personal data without proper consent or security measures, thereby violating data protection legislation and ethical standards. Such a method risks significant legal penalties and reputational damage. A further incorrect approach is to prioritize speed of detection over accuracy and fairness. This might involve using algorithms that are known to have biases or that do not undergo sufficient validation, leading to the wrongful flagging of legitimate claims or the unfair targeting of certain claimant groups. This contravenes principles of fairness and due process, which are implicitly or explicitly protected by regulatory frameworks. The professional reasoning process for similar situations should involve a risk-based assessment. This means identifying potential fraud risks, evaluating the suitability and legality of different data analytics techniques, and implementing controls to mitigate privacy and ethical concerns. Professionals must stay abreast of evolving regulatory requirements and technological advancements in data analytics, ensuring that their fraud detection strategies are both effective and compliant. A continuous review and validation process for analytical models is also essential to maintain accuracy and fairness. Question 17. Operational review demonstrates that a claimant is seeking substantial economic damages following a business interruption event. The claimant has provided projections of lost profits based on historical performance and anticipated market growth, but has not provided detailed records of expenses incurred to mitigate the loss or evidence of proactive steps taken to resume operations. The claims handler must determine the appropriate basis for calculating economic damages. Which of the following approaches best aligns with the regulatory framework for economic damages assessment? Option A. Awarding damages based on the claimant's projected lost profits, assuming the projections accurately reflect potential future earnings and market conditions. Option B. Approving the full amount of projected lost profits as claimed to ensure prompt resolution and maintain a positive claimant relationship. Option C. Denying economic damages entirely due to the lack of precise financial statements detailing every potential loss. Option D. Calculating damages by considering the claimant's historical profits and deducting a reasonable allowance for expenses and mitigation efforts, while requiring further evidence to substantiate the projections. Correct answer is A. Awarding damages based on the claimant's projected lost profits, assuming the projections accurately reflect potential future earnings and market conditions. Explanation. This scenario is professionally challenging because it requires the claims handler to navigate the complexities of economic damages assessment while adhering strictly to the regulatory framework governing the advanced claims exam. The core challenge lies in distinguishing between legitimate economic losses and speculative or unrecoverable damages, demanding a nuanced understanding of causation and mitigation principles as defined by the relevant regulations. The pressure to settle claims efficiently must be balanced against the imperative to ensure that any awarded economic damages are demonstrably linked to the insured event and are not inflated by factors outside the scope of the policy or regulatory guidelines. The correct approach involves a meticulous examination of the evidence to establish a direct causal link between the insured event and the claimed economic losses. This requires the claims handler to apply the principles of foreseeability and certainty, ensuring that the damages are not remote or speculative. Furthermore, it necessitates an assessment of whether the claimant has taken reasonable steps to mitigate their losses, a key regulatory requirement. This approach aligns with the regulatory framework by prioritizing a fact-based, evidence-driven assessment that adheres to established principles of loss calculation and causation, thereby ensuring fair and compliant claims handling. An incorrect approach that focuses solely on the claimant's stated losses without independent verification fails to meet the regulatory standard for due diligence. This approach risks awarding damages that are not substantiated by evidence or are not a direct consequence of the insured event, potentially violating principles of good faith and fair dealing. Another incorrect approach that prioritizes a quick settlement over a thorough assessment of economic damages, even if it appears to satisfy the claimant, can lead to regulatory breaches if the settlement amount is not justified by the actual losses incurred and the applicable policy terms and regulatory requirements. This shortcuts the necessary analytical process and can result in overpayment, which is contrary to the principles of prudent claims management and regulatory oversight. Professionals should employ a decision-making framework that begins with a comprehensive understanding of the policy terms and the applicable regulatory framework. This involves systematically gathering and analyzing all relevant evidence, including documentation of losses, expert reports, and evidence of mitigation efforts. The claims handler must then apply the established principles of economic damage assessment, focusing on causation, foreseeability, certainty, and mitigation. Any proposed settlement or award must be justifiable based on this rigorous analysis and demonstrably compliant with all regulatory requirements. Regular consultation with legal counsel or senior claims specialists may be necessary when dealing with complex economic damage claims to ensure adherence to best practices and regulatory mandates. Question 18. System analysis indicates that a claimant has submitted a complex property damage claim following a significant weather event. The insurer has received a large volume of claims and is experiencing a backlog. The claimant has contacted the insurer via email, phone, and a dedicated online portal, seeking updates and clarification on the claims process. The insurer's internal process dictates that claims are assigned to adjusters within 48 hours, with a full assessment typically taking up to 10 working days. Which of the following approaches best aligns with regulatory requirements and professional best practice for acknowledging and communicating with this claimant? Option A. Send an automated email acknowledging receipt of the claim, stating that all claims are being processed and that the claimant will be contacted within 15 working days. Option B. Send a single email acknowledging receipt of the claim and informing the claimant that due to the high volume of claims, they will only be contacted once a full assessment has been completed, which could take several weeks. Option C. Acknowledge receipt of the claim via the online portal within 24 hours, providing a link to a general FAQ page about claims handling and stating that an adjuster will be assigned when resources become available. Option D. Immediately assign a dedicated claims handler to the claimant who will personally call them within 24 hours to acknowledge receipt, explain the claims process in detail, and provide an estimated timeline for the initial assessment, while also confirming that all communications will be consolidated through this handler. The correct answer is A. Send an automated email acknowledging receipt of the claim, stating that all claims are being processed and that the claimant will be contacted within 15 working days. Explanation. This scenario presents a professional challenge due to the inherent tension between the insurer's need for efficient claims processing and the claimant's right to timely and clear communication. The complexity arises from managing multiple communication channels and ensuring that all parties are kept adequately informed without creating undue burden or misinterpretation. Careful judgment is required to balance these competing interests while adhering to regulatory obligations. The correct approach involves acknowledging receipt of the claim promptly and clearly outlining the next steps, including the expected timeframe for further communication. This demonstrates professionalism, manages claimant expectations, and adheres to regulatory requirements for timely acknowledgement and communication. Specifically, under the FCA's Conduct of Business Sourcebook, COBS, and the principles of fair treatment of customers, insurers are obligated to communicate with customers in a clear, fair, and not misleading way, and to process claims efficiently. Acknowledging receipt and setting expectations for the claims process directly addresses these requirements. An incorrect approach that delays acknowledgement or provides vague timelines fails to meet regulatory standards for clear and timely communication. This can lead to claimant dissatisfaction, potential complaints, and breaches of COBS principles, which mandate that firms act honestly, fairly, and professionally in accordance with the best interests of their clients. Another incorrect approach that inundates the claimant with excessive, jargon-filled technical details without a clear summary of actions or timelines can be equally detrimental. While it may appear to be thorough, it can confuse the claimant, making it difficult for them to understand the status of their claim and their rights, thus failing the clear, fair, and not misleading test. Finally, an approach that relies solely on automated responses without a clear indication of human oversight or a defined escalation path for complex queries risks leaving the claimant feeling unsupported and their concerns unaddressed, which is contrary to the principle of treating customers fairly. Professionals should adopt a decision-making framework that prioritizes clear, timely, and empathetic communication. This involves understanding the claimant's perspective, anticipating their information needs, and proactively providing relevant updates. It requires a thorough understanding of regulatory obligations regarding claims handling and communication standards, ensuring that all interactions are documented and that a clear audit trail exists. When faced with complex claims or communication challenges, professionals should seek guidance and ensure that their actions align with both regulatory requirements and ethical best practices. Question 19. The review process indicates that a claimant has verbally agreed to a settlement amount for their claim and has subsequently sent an email stating, "I accept your offer and want to finalize this. Please send the paperwork to close the file." The claims handler needs to prepare the release agreement, Which of the following actions best represents the appropriate next step in accordance with regulatory frameworks governing claims settlements? Option A. Draft a release agreement that clearly outlines the settlement amount, the specific claim being settled, and a comprehensive waiver of all future claims related to the incident, ensuring it is sent to the claimant for signature after a brief review. Option B. Immediately send a standard pre-approved release agreement to the claimant without any modifications, assuming it covers most settlement scenarios. Option C. Respond to the claimant's email by acknowledging their acceptance and stating that the release agreement will be sent once the claims handler has completed an extensive legal review of the entire claim file, which may take several weeks. Option D. Draft a release agreement that specifically details the agreed-upon settlement amount and the scope of claims being released, ensuring it accurately reflects the terms of the verbal agreement and the claimant's email, and then forward it to the claimant for review and signature, offering to clarify any points. The correct answer is A. Draft a release agreement that clearly outlines the settlement amount, the specific claim being settled, and a comprehensive waiver of all future claims related to the incident, ensuring it is sent to the claimant for signature after a brief review. Explanation. This scenario is professionally challenging because it requires balancing the claimant's need for prompt settlement with the insurer's obligation to ensure a release agreement is legally sound and protects its interests, while also adhering to specific regulatory requirements for claims handling and settlement. The complexity arises from the potential for ambiguity in the claimant's request and the need to avoid misrepresentation or undue pressure. The correct approach involves carefully reviewing the claimant's request, identifying any ambiguities, and then proposing a clear and comprehensive release agreement that accurately reflects the terms of the settlement. This approach is correct because it prioritizes clarity, legal enforceability, and compliance with regulatory guidelines that mandate fair and transparent settlement practices. Specifically, it aligns with the principle of ensuring all parties understand the terms of the agreement, thereby preventing future disputes and upholding the integrity of the claims process. Adhering to the specific wording and intent of the settlement and ensuring the release covers all agreed-upon aspects is paramount. An incorrect approach would be to immediately draft a release based solely on the claimant's informal communication without further clarification. This is professionally unacceptable because it risks creating an agreement that does not fully capture the agreed-upon settlement terms, potentially leaving the insurer exposed to further claims or disputes. It also fails to ensure the claimant fully understands the scope of the release they are signing, which could be considered a breach of good faith and fair dealing. Another incorrect approach would be to present a standard, generic release agreement without tailoring it to the specific circumstances of the claim and the agreed settlement. This is flawed because it may not adequately address the unique aspects of the claim or the specific liabilities being released, potentially leading to legal challenges or an incomplete resolution. It also demonstrates a lack of diligence in ensuring the agreement is fit for purpose. A third incorrect approach would be to delay the process significantly by requiring extensive legal review of a straightforward settlement, thereby causing undue hardship to the claimant and potentially violating regulatory timelines for claim resolution. While legal review is important, an overly burdensome process for a clear settlement is inefficient and unprofessional. The professional decision-making process for similar situations should involve a systematic approach. First, thoroughly understand the claimant's request and the agreed-upon settlement terms. Second, identify any potential ambiguities or missing information. Third, draft a release agreement that is precise, comprehensive, and legally sound, ensuring it accurately reflects the settlement. Fourth, communicate the terms of the release clearly to the claimant, offering an opportunity for questions. Finally, ensure all actions comply with relevant regulatory frameworks and ethical guidelines for claims handling. Question 20. Cost-benefit analysis shows that a thorough investigation into the claimant's role in the accident would be more time-consuming and potentially lead to a lower settlement offer. However, the claims handler is aware that the claimant may have been partially at fault. Which approach best aligns with the regulatory framework and ethical obligations for handling this claim under a comparative negligence system? Option A. Settle the claim for the full amount of damages claimed without a detailed assessment of the claimant's fault to expedite closure and avoid potential disputes. Option B. Conduct a comprehensive investigation to determine the percentage of fault attributable to the claimant and reduce the settlement offer accordingly based on the findings. Option C. Offer a settlement that is a compromise between the full claimed amount and a significantly reduced amount, without clearly articulating the basis for the reduction. Option D. Immediately deny the claim, asserting that the claimant's potential fault, even if minor, bars any recovery. The correct answer is A. Settle the claim for the full amount of damages claimed without a detailed assessment of the claimant's fault to expedite closure and avoid potential disputes. Explanation. This scenario is professionally challenging because it requires the claim's handler to balance the claimant's potential recovery with the insurer's financial exposure, all while adhering to the principles of comparative negligence as defined by the relevant jurisdiction's laws. The handler must accurately assess fault and damages, understanding that a claimant's recovery is reduced by their own percentage of fault. Misjudging this percentage can lead to either overpayment or underpayment of the claim, impacting both the claimant's financial well-being and the insurer's profitability and reputation. The ethical imperative is to act fairly and transparently, applying the law consistently. The correct approach involves a thorough investigation to establish the degree of fault attributable to each party involved in the incident. This requires gathering all available evidence, including witness statements, police reports, and expert opinions, to form a well-reasoned assessment of causation and negligence. Once the apportionment of fault is determined, the claimant's total damages are then reduced by their assigned percentage of negligence. This aligns with the statutory framework of comparative negligence, ensuring that the claimant is compensated for the portion of their losses caused by the other party's actions, and no more. This method upholds the legal principle of fairness and prevents a claimant from recovering damages for their own carelessness. An incorrect approach would be to ignore or downplay the claimant's contribution to the incident, thereby failing to reduce the awarded damages by their percentage of fault. This violates the core tenet of comparative negligence, which mandates a reduction in recovery based on the claimant's own negligence. Ethically, this is unfair to the insurer and its policyholders, as it results in an overpayment of the claim. Another incorrect approach would be to arbitrarily assign a disproportionately high percentage of fault to the claimant without sufficient evidentiary support, solely to minimize the insurer's payout. This is unethical and potentially illegal, as it deprives the claimant of their rightful compensation and can lead to disputes and legal challenges. Such an action undermines the integrity of the claims process and the insurer's duty of good faith. Professionals should approach such situations by first understanding the specific comparative negligence laws of the governing jurisdiction. They must then conduct a comprehensive and objective investigation, meticulously documenting all findings. The assessment of fault should be based on evidence and legal principles, not on assumptions or a desire to minimize payout. Transparency with the claimant regarding the process and the application of comparative negligence is crucial. If there is ambiguity or significant dispute regarding fault, seeking legal counsel or expert opinion is a prudent step to ensure compliance and fairness.